Okay, let us begin. Thank you everyone for joining today. Today's topic for today's webinar is Getting from Here to There, the PGA and Navigating Practice Areas. My name is Karen England. I'm a BCSLA board member and co-chair of the Professional Governance Act Working Group. Joining us today also is my co-chair, Jackie Lowe. She's also on the Professional Governance Working Group, and we share the chairship together. I would like to begin in a good way by saying that we are gathered here today on the traditional and unceded territories of Coast Salish people, in particular the Squamish, Tsleil-Waututh, and Musqueam First Nations. We recognize and respect the history, languages, and cultures of First Nations, Métis, and Inuit, and all the First Peoples of Canada. I have some housekeeping notes to share. Please note that this webinar is being recorded, including the questions and comments that are in the chat window. If you do not want to be recorded, please keep your camera turned off and your microphone muted, and use the chat function to submit questions and comments. So we are monitoring the chat to see if people have questions or comments. We are delighted today to have with us Kate Haines, who is the superintendent at the Office of the Superintendent of Professional Governance in the Ministry of Post-Secondary Education and Future Skills. She's here today graciously giving some time to present on today's topic. Kate was appointed the superintendent in January of 2023. She has served as a member of the OSPG's executive team since 2020. Most recently as the Deputy Superintendent in the Audits, Investigations, and Performance Management portfolio. She has developed and implemented the OSPG's Performance Review Program, taking a phased approach to assessing how regulatory bodies are already meeting or planning to meet the standards of regulation. She certainly is well positioned to speak today to us on this topic and has been really supportive of our efforts to make this transition. So we're very lucky to have her here today. Before she begins, just a quick reminder to keep your mics turned off and to use the chat window to submit your questions. There will be a chance for questions and answers after Kate's presentation today, and we will address all the questions and comments after Kate's presentation is complete. Thank you for joining us today, Kate. Over to you.
Thanks for the warm welcome, Karen, and just also acknowledging that I'm joining you from the traditional territories of the Esquimalt, Saanich, and Songhees nations here in Victoria. And I'll just get my screen share going. Is that showing up, Karen? Great. All right, so again, thank you for having me today. I'm definitely looking forward to having some time to hear from the questions of the broader membership. I've been working really closely with Karen and Jackie and Paul DeGrief as well, who recently handed over the reins to Karen. Learning a lot about landscape architecture. I kind of wish I could go back in time and become a landscape architect, just because it's a truly fascinating profession, and my background is in geography, and I really appreciate that interface between the natural environment and how people make use of that environment, and I see a lot of that in the work of landscape architects. So BCSLA has been very diligent about educating membership about what it will mean to come under the Professional Governance Act, and we've been spending a lot of time in our sort of transition group talking about, okay, what is the practice of landscape architecture? What is it that you do, and how will that fit under the regulation framework of the Professional Governance Act? And I was asked to bring the membership along with a little bit of that conversation that we've been having today. So just a little bit of context for those who have been paying less attention to the process over the last few years. BCSLA first submitted an application for designation under the Professional Governance Act in 2021. So 3 years ago now, the office took some time to review that application, and in the fall of 2022, a recommendation was made to the Attorney General at the time that the profession be designated under the Professional Governance Act. So in the last year and a half, we've been working in a more focused way of looking at, okay, how does that transition operationally happen? It's pretty normal that it takes a few years to transition from a standalone statute to the Professional Governance Act. For all the other 6 regulators, it's been sort of a 2 to 3 year process. So we are well within the normal timeline still. I guess I spoke to the next couple bullets already in my opening remarks, but yeah, so we've where we've been is about, you know, a year and a half since that recommendation for transition. You might be curious about, okay, well, when does the switch flip? When does the Landscape Architects Landscape Act get turned off and the PGA get turned on? And it does require regulation of cabinet. So what I can tell you right now is that we are in an interesting political year in British Columbia. We have an election coming up in October. That means that the sort of the decision-making functions of government go into a bit of a dormant period, probably starting in the summer. And then after the election, it also takes some time for new ministers to get their portfolio under them and sort of start to roll out some of those election commitments. So it would be no earlier than, I would say, early 2025 that landscape architecture would make the transition to the PGA. Some of that also depends upon the technical work that's required to get there. So the things that our office is going to be focusing on over the next, you know, at least 9 months leading into 2025 is that package of regulations that is required to make that legal transition from the current statute that you have to come under the Professional Governance Act. But BCSLA itself also has a fair amount of work to do during this time, and we've seen project plans that speak to the society's operational transition to the current structure that you operate under compared to what the new world will be. That includes the requirement to draft bylaws that are in accordance with the Professional Governance Act, and sort of your organization to think about what is the organizational structure that will support your success under the Professional Governance Act. Are there any tweaks that are needed to get the bylaws and the organizational structures in place? So lots of work to come still, but wanted to let you know in a bit more detail today about all the really good progress we've made over the last year and a half. Just another bit of a context-setting piece. As hopefully you're aware, you currently operate partially under the Architects Landscape Act and also partially under the Societies Act. So what that means is, compared to your future under the Professional Governance Act, there are less specific rules that you must follow in terms of how your organization operates or regulates members. Currently, you do have the protected title of landscape architect that only those individuals registered with the society are able to hold themselves out as. There is no specific requirement under provincial legislation, I believe, that landscape architects have to be retained for certain services, although I understand that some local governments do have third-party requirements for landscape architects to be involved with the submission of certain plans and documents. So thinking about the future under the Professional Governance Act, that will bring a lot of required governance rules that are consistent across the board for all those professions under our Act. So that includes nomination process for board elections, including a merit-based process to be nominated for standing for election. There's mandatory requirements in terms of committees that discharge certain functions of the Act. There's a mandatory register that the society must publish and have everybody who is registered with the society listed on that register. There's another important focus of the mandate of BCSLA is that it will focus on professional regulation only, and advocacy activities will be limited in accordance with the Act. So advocacy that would be completely valid and allowed would be that sort of advocacy for the importance of the use of registered professionals in the public safety context. But advocacy in terms of benefits to the membership themselves, that's one line that is not allowed under the Professional Governance Act. That the entire point of this structure is for registrants to be putting the public interest ahead of themselves, and we can't have the regulatory bodies advocating for their registrants' interests. You are also going to have some new oversight from our office, and this was sort of a big change for all regulatory bodies who come under the Professional Governance Act, is that you have a friendly superintendent sitting over the shoulder of the executive director and the board. We were the first sort of oversight office of this sort in Canada, but in the intervening years, the Health Professions Act has also been updated, and there will be a superintendent coming in the health professions. So it's not entirely unique anymore. And then I guess another big difference for you is that certainly the Act provides for continuing the protected titles that you have, but there is also an option for government to establish a reserved practice at the provincial level for landscape architecture, which is certainly something we are aware BCSLA is interested in having should government decide to grant it. So the terms, you might have heard the terms like practice rights, protected title, right to practice. Those are all definitely terms that are out there in the world, but the terms that we use specifically under the Professional Governance Act are regulated and reserved practice. And I'm going to go into a bit of detail on what each of these things means so that you can understand the conversations that we're having about how each of these pieces might be defined in a future regulation. So just going back to first principles, what's the point of regulated professions in the first place? Having these self-regulated professions, it's really a privilege granted to a profession through legislation where the public interest is important. So we know doctors, lawyers, nurses, accountants, there's all these practices of professions where it's really important to put the public interest at the center of that practice. And in these self-regulation spaces, registered professionals actually have a legal and ethical duty placed on them to put the interests of the public ahead of their own interest. Part of this system can involve granting exclusive rights to practice or use certain titles. This really helps the public understand when they're seeking those types of services who is qualified to practice in those areas where the public interest requires protection. So the first thing that we'll be looking to define for landscape architecture is what is the regulated practice under the Professional Governance Act. All regulatory bodies under the PGA have to have a regulated practice. I like to call this sort of the sandbox of where a particular regulator can regulate. So for example, engineers and geoscientists BC, they generally regulate in the engineering and geoscience space. They generally don't regulate in the medical space because there's another regulator that has been granted that regulated practice of medicine, and it's not the engineers. That regulation, that is a definition that's set out in regulation, and it's really centered around the particular body of knowledge or list of disciplines that the advice and services of the profession must be based upon. In some cases, we've actually further refined that body of knowledge or list of disciplines based on the application of how that knowledge is applied. Sometimes you might have, and we'll get into this a bit later on, there's foundational knowledge that might be common to different professions, but the application of that might be important to have a particular profession in a professional in a forestry context versus a biology context. So this basically sets out the space where the regulator can regulate its registrants. Important point is that it may also include advice or services that are not strictly part of the body of knowledge of the profession, but it's connected to the practice of the profession. So for example, bookkeeping. None of you are bookkeeping professionals, but generally your ethical obligations in regards to proper maintenance of financial records and proper billing practices, it's going to reflect poorly on the profession generally if you don't keep your books in order, if you're doing faulty billing. So in addition to your practice of landscape architecture, the regulator could actually be interested in these other ancillary services to make sure that on the whole, your professional practice is reflecting what is expected of the profession. Project management is another area, record keeping, for example, because record keeping is an important ethical responsibility. So everybody has a regulated practice. Government may choose to additionally define a reserved practice. Oh, these are not the same slides I was thinking of. Okay. So a reserved practice is a subset of what is in the regulated practice. The things within the regulated practice that specifically require the knowledge and expertise of the registered professional. So I'm going to think of an example from the forestry, say the forest sector, is if you're working in the regulated practice, if I plant a tree in my backyard and I have no intention to harvest that tree or create any sort of economic activity from the growth of the tree, their practice might be based on trees, but there's no purpose in like preventing me, Kate, from planting a tree in my backyard. The things that we would actually reserve only for the registrants of that regulatory body are the things that require that foundational knowledge about forest science, and in the public interest, we actually required that knowledge in the context of, timber harvest plans and stand development and whatnot. So not all of the regulated practice is necessarily going to be reserved. And anything that is reserved is still sort of based on that, the foundational knowledge of the profession. So we wouldn't reserve anything to a profession that isn't based on that body of knowledge. So this is something that I know that BCSLA is keenly interested in having government consider establishing reserve practice for landscape architecture. Understanding that there is some of that third-party legislation out there already through some municipalities. So this is a conversation that we're certainly engaged with the transition team on, and I'm sure there will be some more details at some point once we get further down that road. Jackie, did you want to jump in?
No, it's just I was just turning my camera on in lieu of some of the other upcoming slides, but
okay,
yes.
Okay. Okay, here we go. So reserve titles. This is again something that we've talked about that you already have. The title really helps identify those practitioners who are registered and subject to regulatory body oversight compared to those who are not. I could currently I wouldn't be prohibited from practicing landscape architecture, but I couldn't call myself a landscape architect, for example. And sometimes title protection has a lot of value in the market. So it's not to say that reserve practice is the be all and end all of, protection of the public interest. That if there is a very strong recognition of the accountability of those professionals to their regulator and the quality of their education, the quality of their practice, that that government decision makers and employers are actively encouraging and requiring these titles and this registration to engage in practice. I think there is a lot of legitimacy to the importance of reserve title in the different aspects of protecting the public interest and restricting who can do what. All right, this is the slide that I thought was coming earlier. So again, already sort of touched on this stuff, that the regulated practice is broader than the reserved practice potentially. It's all sort of constrained by that body of knowledge or list of disciplines that a profession is based upon. So the conversations that our office has been having with the transition team over the last while has really been helping us understand, okay, what is what is the broad education of a landscape architect? What are the foundational pieces of the practice of this profession, and helping us to understand in the future at least the space that we would be thinking about in terms of what could be recommended to be reserved. All right, so a word that we have encountered frequently in the Professional Governance Act is overlap. And we heard very early on, oh, there's overlaps between the professions, and you're going to have to deal with that. And you can imagine that, there's some sensitivity around the different professions and who does what. And this word overlap was sort of very triggering. And we dug into that a bit more, and we have actually split out the concept of overlap of professionals into three different components. And this was a really important part of our conversations with the transition team, to understand the ways in which landscape architects work alongside their different professional partners in a multidisciplinary context. So the way that we talk about overlap at OSPG, we really mean we're talking about something that requires the identical technical knowledge and competence of two different professionals, and that those individuals could be interchangeably retained to do the exact same practice. So in the regulated, we talked about that regulated practice where there's no restrictions on who does what. We certainly have an overlap in all of our professions around project management and application of legislation, codes, or standards. I know that that's something that landscape architects do. So if I need someone to do project management, I can hire a landscape architect, I can hire an engineer, I can hire a biologist. They're all going to have those foundational skills, and they're interchangeable. We generally don't have overlap in things that are reserved to particular professions. And if we do, it's in very unique cases that have to be really clearly defined directly in the regulation. So for example, in the context of forest roads and crossings, this is building logging roads and bridges. Both foresters and engineers could be retained to do sort of identical interchangeable tasks in that context. Foresters couldn't, do a general engineering project. You certainly wouldn't want the engineers talking about timber harvest, but in this very specific context where there's a sort of joint practice board and joint standards of practice, that you could actually hire either an engineer or a forester, and that is clearly allowed in the regulations. What we find happens a lot more often than this overlap, where you can actually interchangeably use two different professionals, is that we have alignments and intersections. So an alignment is what we would say where you might have two professionals and different regulators might have a similar foundational knowledge in what they learned at school. I'm starting to learn that grading is probably a good example of this, that landscape architects learn about grading, civil engineers learn about grading. But then they go off and they apply that knowledge in a different way that is not actually interchangeable. You could not replace one professional for the other. So another example I like to use in this context is we have a lot of professionals under the Professional Governance Act who know a lot of things about plants. A biologist, a forester, and an agrologist will all have education about plant biology, but the way that they apply that is not interchangeable. If you're talking about wild species at risk in British Columbia, that is specifically requiring the knowledge of an applied biologist. If we're talking about timber harvest, specifically requires the knowledge of a forester. Agrologist specifically in the case of crop yields. So just because they have the same education doesn't mean that they're interchangeable. Their professional development has specialized the application of that knowledge, and you could not interchange one professional for the other in those different contexts. Intersection is another area where we're not even coming with similar knowledge from foundational knowledge. Actually, we're dealing with multiple professionals with different expertise that have to work collaboratively and iteratively to complete a project together. So another example that I go back to here is wastewater treatment. You're going to have water discharge from a wastewater treatment plant. A biologist is going to have very specific knowledge about the fish habitat in the receiving environment, what sort of flows are necessary, what sort of temperatures are necessary, the seasonality of those requirements based on fish spawning. The engineer is going to actually have the knowledge about designing a wastewater treatment process, and those professionals are going to have to be in dialogue. The engineer will say, okay, well, this is what this is what the discharge is going to look like. And the biologist will say, well, no, you can't do it like that because X, Y, and Z. Can you please go back and redesign your wastewater treatment process so that we can get the right specifications of the outflow into the receiving environment? So it can feel, when you have multiple professionals working together on the same project, that's overlapping. And we say, well, no, overlapping really means only that that two individuals are interchangeable. And in this intersection example, everybody is unique and special and bringing something special to the table, and you can't achieve the full project without that multidisciplinary iterative dialogue. So in my conversations with the transition team, certainly what I have heard about is there is a lot of intersection and alignment of landscape architects with other practitioners under the Professional Governance Act, and we're set up for a very constructive conversation when it comes to engaging with the other regulators. And I think we have a moment coming up where Jackie's just going to go into a bit more detail, but I have one more slide I wanted to talk about first. I also just want to recognize that regulatory bodies are typically quite interested in where are the boundaries and making sure that everyone stays in their lane. But what we've also found is that registrants themselves generally do know the boundaries of their practice and their competence, and they are very strongly inclined to stay in their lane. They know that that's a professional requirement, and they do that. We don't want to get in the way of that. We don't want to get in the way of that good collegial multidisciplinary working on the ground. So we try to do our best not to mess things up in the process of defining these things. But there's certainly, as different professionals work together in those edge cases, there are opportunities for the regulatory bodies to be in dialogue about what sort of materials might be helpful to support registrants in the areas where they brush up against each other, help the public understand the context in which they might want different professionals for different types of projects. So that's a real value of the Professional Governance Act, is that we have the regulators in those dialogues and really striving towards that clarity in terms of published materials and supports for registrants and information for the public. So I'll just turn it over to Jackie now for a couple of examples that we've surfaced in our early days.
Sure, yeah. Actually, Kate, would you mind flipping back to your chart of overlap versus alignment versus intersection? Yeah, that's great. Okay, yeah, so I wanted to just give some high-level examples today of what may be potentially considered to be alignment or intersection for us in our day-to-day practice. Again, you know, this is all still very subjective to our ongoing conversations, not only with Kate's team, but also with the other regulators as we get into in future getting more definition around our regulated or reserved areas of practice. So in a very subjective sense, I did want to kind of just come back to these points and highlight things at a high level because again, instinctively, the use of the term overlap is sort of the main sort of instinctive thing that comes to mind, I think, for a lot of landscape architects at first when we think of things like grading or planting or certain aspects of site design, things like that, when we think of what, say, a civil engineer does or what an architect does or what a biologist or forester do. But the breakdown of overlap into alignment is a really good sort of breakdown on this chart. So I just wanted to draw some attention to it. The fact that Kate highlighted that when it comes to overlap, it's driven around specific tasks. You know, so in the example of the engineering and design of a logging road, that's a very specific task to design a logging road. So the fact that the foresters and engineers have demonstrated that they truly had the exact same education and training and credentialing and requirements to get to a point of acknowledging that they truly overlap there. There was obviously a process that occurred in affirming that with each other, regulator to regulator. And as Kate alluded to, there's actually a joint sort of board and process for continuing to ensure that practitioners that take on that particular scope of work are continuing to have the correct education and training in that overlapping sense in order for that to continue to be recognized between those two regulatory bodies. So, you know, I wanted to just highlight that because at first, you know, our initial instinct might be, well, hold on, like we grade things too. Yes, we do. But the lens to which we grade is different than the lens to which, say, a civil engineer or an architect may grade. So looking now at the definition of alignment, I just wanted to give an example there. Let's just think, for instance, you know, a park requires a master plan. The approach we would take as landscape architects to developing a grading plan in that park would be a very different approach to other professionals. And so if we're taking on the task of grading the park, yes, at a high level, we may have similar knowledge and education to the engineers in terms of best principles of approaching grading strategies, analyzing the site, performing sort of high level analysis, things like the rational method, things like that to understand what some of the sort of capture and requirements might be for stormwater on the site. But ultimately, when it comes to executing the work, if the landscape architect is taking on all the surface grading in that master plan and that park design, at the end of the day, we would still need the engineers to come in and ultimately deal with the engineered design of the tie out and outfall of that stormwater from the park out into the greater utility network. So there's still a very clear sort of separation of tasks within a project in that example. So it's when I think of alignment, I tend to generally think of scopes of work. So different tasks within a project, different scopes, but we're coming together and we're coordinating with each other. Whereas in the intersection, that coordination deepens into even more of a collaborative, iterative process where it's not as simple as saying, hey, you know, we're going to take the reins of leading the site grading here, and we want to coordinate with you on the outfall and, you know, the depths on things and make sure that everything's okay. In intersection, it's more like, hey, we need to talk to X, Y, and Z additional professionals in order for us to complete our very specific task and get it done in a very iterative and very collaborative way. So when I think of intersection, it's more like examples of, you know, let's just say we're dealing with a steep site and we need to have multiple terraced retaining walls or something get developed in the landscape master plan that's going to require us to still work iteratively back with, say, the building architect on entry and egress points out into this terrace courtyard scenario, or coordinate with the engineers on depths and clearances above utility pipes, coordinate with the geotechnical engineers on the offsets of terraces and the structural integrity and relationship between those terraces and the foundation of the building. Things where we might need to go back and forth and have very collaborative communication and dialogue in a very iterative process to refining, resolving a design, often still leading us to still have different cross-references back to those other consultants' pieces of their work, is way more in that intersection frame of the day-to-day of what a lot of our work entails. And so hopefully that just gives a little bit of clarity on some of the whys and hows of how a lot of our discussion to date has really been focused more on alignment and intersection examples as we've been getting to discuss these things with Kate and prepare to enter into more engagement with the regulators coming up this year. If you have any questions or need any other scenarios or examples, please, by all means, let us know. And Kate, was there anything you wanted to add on to anything I've just expressed?
No, that was great. Thanks very much, Jackie.
Thanks.
All right, so I'll get back into. All right, so sort of what's next? We talked, I spoke sort of at a high level of what both BCSLA and our office are going to be doing over the next nine months and beyond. But then specifically in regards to this regulated and reserved practice piece, I think that OSPG has been quite sufficiently educated now, and we've done a lot of preliminary identification of intersections and alignments. We have a lot of things that are already reserved in the Professional Governance Act. So if we were running into a lot of overlaps at this point, it would kind of provoke a question of like, why are you practicing in an area that's already reserved to somebody else? Fortunately, I'm not encountering that, so I think we're in a pretty good position to have really good constructive dialogue with other regulators. So the next step is that we are now working on some materials to go meet individually with each of the PGA regulatory bodies to test and refine our understanding of that multidisciplinary context for landscape architecture. So based on that engagement, our office would develop instructions for basically government lawyers to do the legal work of drafting the regulation that would eventually be approved by cabinet as part of bringing landscape architecture under the PGA. So just sort of to recap, we definitely have to define a regulated practice for landscape architecture. Otherwise, BCSLA doesn't really know what they're regulating. And then another part of that process is going to be making a recommendation whether to define a reserved practice or not. And I'm sure that we'll be giving more updates sort of as that process goes through, because it's of prime interest to membership, I'm sure. So just before we wrap up, I was asked to also do a little bit of sort of education around a little snippet of the PGA related to standards of conduct and competence, and link this back to some information that might have been given about declarations earlier on in the application for designation process. I mentioned earlier sort of the piece around the Professional Governance Act bringing a fair amount of requirement and structure to how professions are regulated. And this is one of those things that BCSLA is going to have to do, is do their part in respective standards of conduct and competence. So the PGA requires all regulators to establish standards of professional conduct, standards of ethical conduct. Ethical conduct, there's actually sort of the skeleton of a code of ethics directly within the PGA. That is the foundation that must be included in all codes of ethics. It was sort of cobbled together from the best of all those work that were out there to make sure everybody had all all regulators under the Professional Governance Act. There's a common accountability of despite the particular profession that someone is registered in, there's a knowledge that, oh, if you're under the PGA, this is the baseline ethical requirements that I know that you're accountable to. Standards of professional conduct, that has a bit less to do with ethics, but maybe for like how you practice the business management, the professionalism aspect of your practice. Also required to establish standards of competence. That comes in a couple different ways. It can come through, what is the competence required to enter the profession? And you certainly have that through your credentialing process that exists already under the current regime. But then also, what sort of resources are helpful to landscape architects in their day-to-day practice to know that they're meeting the technical requirements of their practice. And I understand that there is some sort of technical documentation out there on areas of practice for landscape architects, which would contribute to this. And then the regulator also has to be there for you to support you when you have questions about those professional and ethical issues, whether that's sort of written material or someone who actually answers the phone. That depends on the capacity of the regulator. But we want regulators to be supporting their registrants and doing a good job, and never even getting to the place where discipline and complaints are an issue. We find that these standards are sort of standards set by the regulatory are really important in a lot of ways. That they describe this directly observable and measurable knowledge, skills, and attitudes that is really required by professionals to provide a professional level of service. So it helps you as registrants in guiding your daily practice. It helps proactively establish a standard if you're hearing complaints about practice, if you can sort of objectively measure and refer and understand whether the complaint has merit or not. And then it's also very important for the consumers of your services, whether it's your employers or the clients who retain you, or general members of the public who have, an interest in what's going on in the developments in their community. It's very helpful for them to be able to go to the regulator's website and understand generally what sort of expectations landscape and architects and other professionals are being held to. So it can be easy to think about professional regulation as like, okay, well, there's a gatekeeping function to let people in, and then there's a complaint function about, when things go sideways. But we really want, like, registration as a point of time, and hopefully not too many people are having complaints against them. We really want to make sure that registrants who are driven to excellence in their profession, that the regulators are really there to support that high level of professionalism and technical competence. So you might have heard sort of over the years reference to competence and conflict of interest declarations. And there has been a bit of this, as originally drafted, this was quite an onerous requirement. And you might have heard about it, and I'm just here to tell you, don't worry about it. We've made some changes, and it has vastly reduced the administrative burden. So as originally drafted and passed in the legislature in 2018, the PGA was going to require professionals on individual projects to file a competence declaration and a conflict of interest declaration for each project with the regulator. And I can imagine the number of projects that individuals are involved in. Regulators their heads were spinning at the concept of like managing this filing system. And as we dug into it a bit more, we recognized that certainly there might be very good reasons to have transparency, that professionals are competent to do their work and that they are not engaged in conflict of interest. But there are definitely ways to achieve this goal without sort of that administrative burden of filing individual declarations. So it shows up in different places. One thing that you will that you will find as there's a transition to the public register under the Professional Governance Act is that we expect an annual self-declaration of practice areas. So that is put on the public register. So rather than filing a declaration of competence for individual projects, we would like you to put on the register, these are the 3 areas of my main practice. And what that is really helpful is if someone is thinking of retaining you for a particular type of work, that they can go onto the public register and see, oh yes, I see that this person has declared a practice area of X. And, or if you go to the register and that practice area isn't declared, then that's a conversation to have with the potential service provider is like, well, I need to do this. And you say you're not mentioning this as one of your areas of expertise. So can you refer me to somebody else, right? There's a question, like each regulator has had a bit of a process of rationalizing their list of practice areas. It typically gets sort of self-generated with over the years, people self-reporting, I do this, and then you end up with a list of like 85 practice areas. I would expect it's something that BCSLA will have to do at some point is rationalize that list down to something a bit more manageable. Then the other piece around code of ethics is that, rather than filing individual conflict of interest declarations on each project, there is an actual requirement in the code of ethics that you do not engage in conflict of interest. So there's opportunities to make sure that registrants are very well educated on that conflict of interest requirement, very self-aware of, when engaging in individual projects, having that self-reflection, is this appropriate? Should I refer this project to a colleague because I can see a potential for conflict of interest? But that is an approach we think that makes sense, given sort of the administrative burden potentially of individual filings. So the Act still does provide that those declaration provisions could be turned on by a case-by-case basis, and I expect that would have to do with public interest and risk, and we haven't identified any cases yet where we want to actually turn it on. But we felt it was more appropriate to sort of use it, have it available for a targeted application if needed, versus sort of imposing this administrative burden across the board. So that is the end of my slides, and I'm certainly happy to take questions.
Thank you very much for that comprehensive presentation, Kate. I really appreciate it. We've got time for questions, and if you've got one, the thing to do is to put it in the chat, and we are monitoring that to see if anyone has anything that they want to ask. Maybe I'll just start things off asking a question. You said that our board will now be merit-based, so there'll be nominations to the board that are based on merit. Would you be willing to speak? I know it's on my mind because we've got our AGM coming up this weekend, and we'll be having elections, and in the future under the PGA, that process will work differently. Would you be willing just to speak a little more to that?
Yeah, so one of the recommendations in the Professional Reliance Review, which was sort of what created the Professional Governance Act, was that there's a concern sometimes that people are standing for election based on a platform of like, these are the things I'm going to do for the members. I'm going to lower fees. I'm going to stick it to the government about X, Y, and Z thing. And the sort of preparedness and the competence and the readiness of that individual actually to contribute positively to a board that has a public interest mandate. That was a little bit, there's a tension between that. So the requirement under the Professional Governance Act, there will be 7 elected registrant board members to the board. And there will be a mandatory nomination committee that oversees the nomination process. So anybody is still welcome to put their name forward to be nominated. There are some merit-based selection principles in the regulation that must be followed. And then those individuals that the committee finds to be suitably merit-based to enter put their name forward, then their names will be put forward for election. So there still will be an election, but there's a bit of a screen here to make sure that people firstly have some education about like what it actually means to be on the board, and like, no, you can't lower registrant fees because it feels nice to pay less money. That the public interest mandate is front and center, and that the individuals putting their names forward have the skills and the competence to contribute positively to that board. And then you will also have 4 lay members who are appointed through a government process. And similarly, there is a merit-based selection process that our office assists with, both with recruiting and appointment. And those individuals are really there to provide an outside perspective from the profession. It's impossible for 4 individuals to like represent the public interest of all British Columbians, but you know, professionals hang out with each other a lot, and there can tend to emerge some groupthink sometimes in professions. So the idea behind those lay board members is to just say, hey, like, from an outside perspective, not knowing much about, you know, this matter, have you considered X, Y, and Z, you know, and how this might read with the public? So that's what you can expect with your board going forward. There will be a 12th individual who is the immediate past board chair, and they will be non-voting for a total of 12.
So quite different than what we've got now. Quite a different process.
Yeah.
We've got a question in the chat about overlap, alignment, and intersection. The question is, what is the PGA approach to practice by individuals that are registered with different regulators? Someone, for example, who's regulated as an architect and a landscape architect.
Yeah, so it's quite common actually that you'll have dual registrants. We see engineering geoscience registrants. We see applied biology, agrology registrants, dual registrants fairly often. And I think it's really good for professionals to be aware that, hey, you know, just because I'm a biologist doesn't mean that I automatically can practice over there. I need to show to the regulator that, yes, I have the skills and the competence to practice over here. And then when I'm practicing over in the other place, then I'm being held accountable to the standards of the other regulators. So and now it's quite helpful in that you as a registrant would know that, oh yeah, my obligations under the Code of Ethics, they're pretty much the same no matter which regulator I'm registered with under the PGA. So there's some nice alignment there that you could expect sort of a better experience being registered with multiple regulators, and then just sort of consider which lane you're practicing in at any different point in time, and make sure that you're following the standards that are in place for that particular area of practice from the correct regulator.
One of the nice things about the PGA is that there'll be similarity between the structures of a different organization, and we'll be kind of swimming in the same waters as far as rules and regulations are concerned.
Yeah. It's one of the real hidden benefits, I think, of the Professional Governance Act is the way that we've brought together regulators who, you know, previously may have sort of passed as ships in the night, or maybe come together on specific projects, but the value of having sort of that regular collaborative interaction and learning and you know, disseminating best practices and being aware of issues that their counterparts are facing, it has, I think, really benefited registrants and British Columbians, but it's kind of hard to quantify.
I guess in early days, maybe there'll be other examples as time goes on, more concrete examples. I'm not seeing any further questions. Is everybody shy?
I'm not scary.
No further questions? Okay. If that's the case, is there any concluding remarks that you'd like to make, Kate?
Just really, you know, acknowledge the really hard work of a volunteer board that BCSLA has brought this designation to the place where we are today. Acknowledge all the contributions of Tara as the executive director over the years, and wishing her well in her retirement. But yeah, it's been a wonderful journey working together, learning more about the profession, and us having now 4 years of experience under our belts that you are benefiting from our lessons learned about establishing a number of these regulated and reserved practices. So hopefully it'll go a bit smoother this time.
It's nice to have not be the first. Alana had clapping hands up, but maybe she was clapping for Tara and wishing her good luck. Alana, did you want to ask a question? No, she's just clapping for Tara. Okay. Okay, I think that I will sum things up then and say thank you again to Kate, and remind people that if they have any further questions, all they have to do is send an email to the office. The PGA working group is around, will be around at the AGM, the members of the working group, and we're happy to answer questions if something comes to you in the night tonight that you want an answer to. Remember to watch the Friday file about notice about when this recording will be available for others to watch. You don't have to watch it live, you can watch it. The recording will be available afterwards. And I have a request to remind people about the party after. Kate, this is what the BCSLA Landscape Society also does really well. We also do really good parties, and that's thanks mostly to Tara. We're supposed to do a plug for the April the 20th AGM 60th Diamonds anniversary. So this is our 60th anniversary this year, and there'll be a celebration at the end of the AGM. And that's it for us. Thank you to everyone who joined us today. I look forward to seeing you on Saturday, hopefully most of you.
Thanks, everyone.
Thank you, Kate.
Night.